All right. So everyone can see the slide now. Okay. So the sources of law itself. Okay. So the sources of law. What are the different sources of law that we know? Let's raise your hand and go ahead. Go ahead.
Um, Legislation, constitution, custom, and convention.
Okay. Lovely. Go ahead, Jada.
There are legal sources, historical sources, and literal sources.
Okay. The different types of sources there. Any other general sources? Any other responses to the sources of law?
Common law, equity.
Common law and equities are also different sources. All right.
Sir, what about customs and conventions?
Customs and conventions. Okay. So those are there as well. Mm. Anything else? I'll talk about custom and conventions, but I don't think it is in this slide here. But we'll discuss it, right? While we're here, we'll discuss it. That should be no problem. All right. So let's have a look at this now. There are three main sources of law. There are literary, historical, and legal sources. All right. So the literary sources of law, right? Understanding the terms, the literary sources rather, right, speak to law coming from various documents, texts, and writings that provide evidence for legal principles, rules, and doctrines, right? So we're looking at how these different texts can revolutionize our understanding of law itself and how we interpret the law and apply the law as well, right? They're also vital to legal research and education. Within the Commonwealth Caribbean, the constitution, legislation, and statutory interpretation, right, are critical components in the legal framework, right? So each play a vital role in ensuring the rule of law, protecting individual rights, and maintaining functional governments, right? So let's start off with the Constitution, right, in Commonwealth Caribbean states. So what do we know about the Constitution as a source of law so far? What do we know? Go ahead.
In the Caribbean, it is the supreme law of the land.
The supreme law of the land. Okay, lovely.
And if any law is inconsistent with it, it shall be null and void.
All right, we're looking at the doctrine of ultra-virus. Lovely. Null and void. Unconstitutional. All right. Anything else about the Constitution that we note? It's the highest source of law. It's pure source of law, right? Of which the law flows within the jurisdiction of a Commonwealth Caribbean state. Body of law containing the rules which determine the direction of the state. Okay. It serves as the parent law on which all other laws are measured. Right, it's the most important source. Okay. So the importance of the Constitution, we know that it's the supreme law which provides a foundation for all other laws and government actions and outlines the structure of government, the separation of powers, and the rights of individuals. Right? So not even the parliament can disobey the Constitution with impunity, without impunity. Lovely that. Lovely for that, right? That's an interesting thing to look at, especially when we look at the public law and the argument that Parliament loves to make about how they have the power to change the Constitution, but the Constitution outlines the procedures that must be carried out for in order for it to change, right? Then I look at those type of stuff in the public law. The saving law clauses are important characteristic of the Constitution. So this laws ensures that continuity of existing laws, right, when a new constitution is enacted, allowing them to retain in force until they are repealed or amended to conform rather with the new constitutional framework, right? For example, in Jamaica, the Constitution saving law clause is found in section 26, which stipulates that laws existing before the Constitution came into force remain valid until altered by legislation. So all these different laws are still valid, right? Un- Unless they're changed by the parliament, they're all still valid, right? So we're looking at those type of laws there. Okay. So the Bill of Rights, specifically the Bill of Rights, is another important aspect of the Constitution. So Bill of Rights enumerates and protects fundamental rights and freedoms of individuals, serving as a safeguard against governmental abuse, right? So looking at all those type of things, the Constitution of Barbados includes a comprehensive Bill of Rights in Chapter 3 of their Constitution, which guarantees rights such as freedom of speech, freedom of assembly, and protection from inhumane treatment. We'll be speaking about inhumane treatment when we talk about Pratt v. Morgan, right? And well, R.V. Pratt and Morgan, right? Looking at those words, Pratt and Morgan, right? When we look at that case, we'll look at that specific thing there. The framework for government is another important aspect. So the Constitution delineates, right, the structure and the powers of the governmental officials, right? It typically divides the government into executive, legislative, and judicial branches. So the separation of powers, the SOP, is in the Constitution. Within chapters 3, 4, and 5 of the Trinidadian Constitution, it details the roles and powers of the president, the parliament, and the judicature, right, or the judiciary, respectively, right? So chapter 3 is the president, chapter 4 is the parliament, and chapter 5 is the judicature. Alright? So giving examples from Caribbean constitutions here. So that is generally it for the constitution, right? For legislation now, what are the two types of legislation that we talk about?
Primary and
Sub-
secondary.
Primary and secondary, or primary and subsidiary legislation. What is legislation though?
Legislation is a process of making laws.
Okay, the process of making laws, right? So the parliament makes and churns out the laws, right? And the executive approves it, right? And the judicature enforces it. So speaking about all of these different things. So the importance here, legislation in the Commonwealth Caribbean states is crucial in creating detailed and specific laws that regulate various aspects of society. Alright? It ought to reflect the will of the people through their elected representatives and provides a legal framework necessary for governance and social order. Right? So it ought to reflect the will of the people. Alright? Does it? We don't know. We can have a discussion about that, but it ought to reflect the will of the people. Alright? So we have two types of legislation. We have primary legislation, which is passed by the principal legislative body in the country, such as the Parliament or Congress, depending on which country it is. And these laws form the core legal framework and outline the fundamental rights, obligations, and structures within the state. Right? So I have primary legislation there, looking at those frameworks. And then we have the characteristics of primary legislation, right? So it has an enactment process and it has the scope and authority. So the enactment process, we know that primary legislation is usually proposed as a bill, debated on in Parliament, then possibly amended from the debate in Parliament, then it is passed using a majority vote. It becomes a law after receiving assessment from the head of state or the Governor General. So after the executive branch looks at what has passed in Parliament, then it becomes a law after that. Alright? The scope and authority now, primary legislation provides broad and fundamental legal principles and is often referred to as acts or statutes. So looking at these examples in Jamaica of the Child Care and Protection Act of 2004, right? So looking at that, it provides comprehensive guidelines for the care and protection of children in Jamaica. Trinidad and Tobago has the Dangerous Drug Act of 1991, right? This act regulates the control, distribution, and penalties related to dangerous drugs in Trinidad and Tobago. Barbados has the Education Act of 1981, right? So this act outlines a framework for the education system in Barbados, right? Including provisions for school administration, teacher qualifications, and student rights. So we're looking at examples of these different forms of primary legislation. As for subsidiary legislation, right? Subsidiary legislation is also known as secondary or delegated legislation. So it refers to rules, regulations, orders, or bylaws made by an authority or a body under powers conferred by primary legislation. Right? So note the difference between subsidiary and primary legislation. It allows for detailed administration and implementation of broader principles set out in primary legislation. So primary legislation is the overarching term, the generalization of what the law should be, and then the primary legislation would give power to other bodies to produce subsidiary legislation now, right? That are no way more detailed than the general primary legislation. So characteristics of subsidiary legislation now, for their enactment process, these types of legislation is usually created by a government, minister, an agency, or local authority under specific powers granted by primary legislation, right? The scope and authority now, while subsidiary legislation has a force of law, it operates within the framework established by the primary legislation and cannot contradict primary legislation. So the subsidiary legislation cannot contradict the primary legislation that it's under, right? So it cannot contradict that. Some examples: the road traffic regulations, right? In 1938 by Jamaica, right? It is under the Road Traffic Act, which is primary legislation. So the regulations is subsidiary under the primary legislation, which is Road Traffic Act, right? In Trinidad and Tobago, we have the public health, right? Generally speaking about sewage and waterways regulations of 2000, right? Which are under the public health ordinance, right? So notice how subsidiary or secondary legislation is under primary legislation. Barbados has the National Insurance and Social Security Benefits Regulation, regulated under the National Insurance and Social Security Act. So notice how the subsidiary legislations are conferred under the power of a primary legislation, right? And cannot contradict it. Everything makes sense so far? Everything's lovely, right? So it's underneath some primary legislation, right? And then we'll move into statutory interpretation. All right? For statutory interpretation now, what do we look at under statutory interpretation?
Interpreting the laws, like application of the laws, how it's being applied due to the three rules: the literal and the golden and the mystery rule.
Okay. Lovely. Zaria, go ahead. Zaria was saying something. I never heard what she said.
I was going to say the literal rule, mistress rule, and golden rule.
The golden rule. All right, lovely. So we generally have four: the literal rule, the golden rule, the missive rule, and the purposive approach. But we tend to just put the purposive approach with the mischief rule, right? So looking at those type of stuff. So how the courts interpret the law, right, as Matthew stated, determining the meaning of legislation, as Ellie stated. All right, so we have those stuff. So statutory interpretation, definition and importance. So statutory interpretation involves the process by which the courts determine the meaning and application of legislation, right? Since statutes may be vague or ambiguous, courts have to play a critical role in interpreting these provisions, right? So they have to read through the statute now and try to figure out what exactly Parliament is trying to do, or what exactly Parliament is trying to correct in society, right? So looking at those type of stuff. So what are the issues that may lead to some amount of judicial interpretation, right? Ellipsis. Ellipsis in legal language refers to the omission of words or phrases that are implied by the context but not explicitly stated. This can lead to uncertainty about the exact meaning of application or application rather of the law. So why does it require judicial interpretation, right? For example, with incomplete phrases, judges need to fill in the gaps to determine the full meaning of the statute. They have to infer the missing words based on the context and the statute's overall purpose. So an example is if a statute says no person shall ellipsis without a permit, right? The court must determine the specific actions that are prohibited without a permit. In doing so, the court interprets the statute's intent and the activities it aims to regulate, right? So if it's not explicitly stated and we use ellipsis in the legal documents, right, then the judiciary has to interpret it, all right? Generalizations, they occur when statutes use broad or vague terms that can cover a wide range of situations. These terms often lack precise definitions, leading to varied interpretations, right? So broad language is one of the reasons why judicial interpretation is needed for generalization. Courts must interpret the scope of general terms to decide how they apply to specific cases, right? So this involves defining the limits of the terms, and ensuring that the interpretation aligns with the legislative intent. An example would be a law that prohibits unreasonable noise. What does unreasonable mean? What is meant by unreasonable noise? Who determines unreasonable noise? These things are generalizations, and the court has an important role to play in establishing the criteria or guidelines for this determination. Makes sense, right? Makes sense so
Yes,
far?
sir.
All right, lovely. Makes sense. Ambiguity now. Ambiguity arises when statutory language is unclear or open to multiple interpretations. This can happen due to poor drafting, conflicting provisions, or complex subject matter. Right? So it requires judicial interpretation in the ways in which we have multiple interpretations. Judges may choose the most appropriate interpretation that reflects the legislature's intent and promotes justice. This often involves looking at the statute's context, legislative history, and purpose. So an example would be if a statute says all vehicles must stop at the intersection, the term vehicles might be ambiguous. Does that mean that only trucks and cars are subject under this law? Or do bicycles count? Do motorcycles count? It is ambiguous, right? Therefore, it is up to the courts, right, to interpret whether or not these things fall under the law. All right, so we have that there. New situations occur as well, right? So new situations refer to circumstances that were not envisioned or explicitly addressed in the statute, right? So in this case, now we must interpret for, especially when it applies to adaptation to change, right? So courts must extend the application of existing laws rather to new scenarios, ensuring that legal principles remain relevant and effective. This often involves interpreting statutes in a way that addresses modern issues within the framework of the original legislative intent, right? For example, cybercrime laws enacted before the rise of social media might not be explicitly covered under online harassment, right? Courts may need to interpret older statutes to apply to new forms of communication and conduct. So as society develops, there are new ways of breaching societal conduct, right, that were not previously envisioned under these laws. So it is now the court's job or the court's role to now interpret the legislation to make sure that these new circumstances do not go untreated. Cybercrime is a very important aspect of those new situations, right? Because 50 years ago, we wouldn't have thought about, right, the types of crimes that could be committed today. So we have to interpret those old laws, right, in such a way that it does cover the new laws or new situations that arise today. We also have general errors. Errors in statutes can lead to typographical mistakes, can include rather typographical mistakes, drafting inconsistency, and unintentional omissions, right? These errors create confusion about the law's requirements and application. So why do we require the interpretation? Especially for correcting mistakes, right? Judges must interpret the statute in a way that corrects obvious errors and aligns with the legislative purpose. This ensures that the law functions as intended despite the drafting mistakes. For example, if the statute mistakenly refers section 13 instead of section 3, the court must determine the correct reference by examining the context and intent of the legislation. So that could be a mistake there. They reference the wrong section, right? So now the judge must take it upon his or herself to now look through the statutes and laws to figure out what was this legislation trying to state, right? How can we alleviate these errors within the statute? Right? So these are reasons why we use judicial or statutory interpretation methods. And we have general interpretation methods, and the first one is the literal rule. So a literal rule is looking at the interpretation of plain, ordinary, and literal meaning of the words, right? So this method assumes that the legislature has said what it means and means what it has said, right? So this is specific to the legislature, to the words coming out of the paper, right? So application, the plain meaning. Judges apply the statute as it is written without considering any external factors such as purpose of the legislation or potential consequences of literal interpretation. they interpret the legislation completely literally, right? So we have that there. So let's have a look at this. We have the Sussex Parage case of 1844, Baptiste versus Alain in 1970, and R versus Ransomnahai and Duke in 1961, right? So what is happening here for Baptiste versus Alain?
This is with the choking of the woman. So the defendant was found outside of her house with his hand through the window choking a female occupant. And he was charged under the conviction. He was charged and convicted of the offense found in the building with intent. But literally he was not found in the building, so they applied the literal rule. Only his hand was in the building. So his conviction was dismissed.
Lovely, right? So Michael de la Baptiste, right, who was an appellate justice, right, looking at that, he stated or posited in obiter dictum, right, that he cannot, in the court's view, be said to have been found in any building on a literal meaning or ordinary interpretation of the words of the Larceny Act. The Larceny Act refers that the person must be convicted of such an offense, right? For the person to be convicted of such an offense, there must be a clear and unmistakable evidence that he has been found within the building. Right? Only his hands were in the building. Therefore, cannot be convicted under that offense. Right? So we're looking at that with Baptiste and Alain. Right? Okay? So that's an example there. So you guys should be able to figure out R versus Ramsonahai, right, and Duke 1961. What happened in that case? Nobody knows what happens in that case?
So, sir, it's a mouthful. The appellant had conspired to and did plan 2 bottles of Bush Run Muhammad Ali, which the police eventually found him to have in his possession. So the police brought a charge against Muhammad Ali, but he was acquitted when it became clear that the witness lied. The public prosecutor later laid charges against and prosecuted the appellant. The indictment charged conspiracy to persecute Muhammad Ali, knowing him to be innocent of the offense of being in lawful possession of bushram. It was an elementary point of criminal procedure that the police prosecutor, not the individual who makes the complaint to the police in the first instance, is the one who persecutes. Sir, this case. Alright, so it was held that the words to persecute are to be construed in their strict sense and are not to be extended to include a conspiracy between 2 or more persons to cause another person to be persecuted by a public prosecutor and is not a party to the conspiracy.
Interesting. So what are we looking at here? What we're looking at here is the ordinary, right, or the literal interpretation of the words to prosecute, right? So what they were looking at is the basis of that word there, right, and how it was used, right, by persons other than the police prosecutor to try to prosecute Muhammad Ali. So we're looking at the literal definitions of that phrase there, right? So that's really a part of the literal rule there. For the golden rule, however, the golden rule is a modification of the literal rule. So it allows the courts to deviate from the plain meaning of the words to avoid any absurd or unreasonable results, right? So looking at that, if a literal interpretation leads to an absurdity, the court can modify the meaning of the words to produce a sensible outcome. Our main case here is Davis v. R. What happened in this case?
Sir, can you bring it back to the golden rule slide, please?
Okay, the golden rule is there. So I will look at that. Can anybody speak about Davis v. R 1962, I believe?
Sir, I can skip.
Alright, no problem.
The defendant was convicted of the offense of parking a vehicle elsewhere than in a place provided for the purpose in a manner required by an authorized officer. And the Court of Appeal found that a literal interpretation of the regulation made nonsense of it. If the word and was used conjunctively in the sentence, it would mean that it was illegal to park unless there was both a place provided for that purpose and in a manner required by an authorized officer. The court has the power to reinterpret that.
Alright, so we're looking at that. So we're looking at what the issues of the law itself really placed, right? And how the court had to use some amount of they had to jump through they had to jump through some hoops basically to change the interpretation of the law to make sure that it doesn't lead to any type of absurdity, right? So the court was looking at the regulations, right? Itself that actually created two separate offenses instead of the one that they were trying to prevent, right? So the court had to interpret it such that any absurd or extra offenses weren't made for that Davis v. R. For the mischief rule or the purposive approach, right? The mischief rule requires courts to consider the statute's intent and purpose, specifically focusing on the mischief or the defect in the common law statute that was intended to be remedied. Alright? So let's look at the legislative intent. So that is the application of this rule. Judges look at the historical context and specific problem the statute was designed to address, and then this helps them to interpret any ambiguous provisions in a way that effectively tackles the mischief or the issues the statute aims to resolve. Alright? So the main cases for the mischief rule would have been what? Right? It would have been the rule was stated out in the Hayden's case, right? In the Hayden's case, Hayden's case in 1584, right? We had these rules placed here, right? So what are the things that we need to look? The four factors we must consider, right? What the law was before the statute was passed, right? We're looking at what the problem or the mischief in the statute was trying to be remedied. We're looking at what it was trying to remedy, right? We're looking at what remedy the parliament was trying to induce, and we're looking at the reason for this remedy. So we're looking at those four factors that will help us determine whether or not the mischief rule is used, right? We also look at the dictum of the Magor and St. Mellons v. Newport Corporation case, right? And that was, I think, in 1950, right? What did Lord Denning state here? Lord Denning did state, right, that we do not sit here to pull the language of Parliament to pieces and to make nonsense of it. We sit here to find out the intention of Parliament and carry it out. And we do this better by filling in the gaps and making sense of the enactment, right? So that's what the mischief rule is all about. So filling any type of gaps, interpret the absurdity of the legislation itself, then try to interpret it in such a way that it actually fixes the issue, right? And the two main cases that we look at here are R versus George Green 1969 and Fraser versus Greenway 1991, right? So R versus George Green 1969. This was the marijuana case, right? So it's a case about the Dangerous Drug Act and whether or not you're supposed to use a pistolette of the plant cannabis sativa, or you're supposed to use a different form, right? So that was really looking at that act there, the International Convention of Dangerous Drugs, as well as its intersection with the Dangerous Drugs Act. We could look at that there for that case. And for the Fraser versus Greenway case, I think that case was about the Land Surveyors Act, right? So that case was about the Land Surveyors Act. So there were ambiguities within the case for George Green and for Greenway, right? And we're looking at how the court actually took it upon themselves to really interpret the law in such a way that absurdity was diminished. All right. So these are some case laws. All right. So we're going to move on to the English perspective for common law.